Hey everyone, this is CACS Tejal Katariya, and with lots of energy we are going to start with today's session in which we will be discussing RTP, which is applicable for June 2023 attempt. All the amendments we have already covered, so please go through that lecture. The second thing, all the questions which are there in your RTP, almost 20 questions are there, which we'll be covering in this session. Along with that, afterwards I'll be uploading the session on mock test, all the 2 mock tests, and so please go through them also because they are very important from your examination perspective. The next thing is we'll be starting with the first question, and let me also know in a comment section if you want me to make a video on some concepts or some difficult points, so that I can get the idea and then I'll be making videos accordingly. All right, so start with the today's session. The first question is, state which of the following agreements are valid contracts under the Indian Contract Act 1872. So basically we supposed to see that whether we can find all the essentials which are given in section 10 and all the essentials which are not given under section 10 of Indian Contract Act are presented in the given case or not. So first case is, A, who owns 2 cars, is selling red car to B, and B thinks that he is purchasing black car. So understand whether this agreement can be a contract or not. So very clearly you can see that this is not a contract. Why? Because there is no consensus ad idem, that is meeting up of minds. Like I am thinking something else and the other party is thinking something else, so it will create a trouble, and that's why A is thinking something else, B is thinking something else. B is thinking that he is buying black car, A is thinking that he is selling red car, so there is no meeting up of minds. So consensus ad idem is missing, and that's why this is not a valid contract. The second is, A threatened to shot B if B does not lend him 2 lakh and B agreed to it. That means there is a contract. See, one is saying that I want a money against which I'll be giving you something, that is offer and acceptance, and then we get the agreement. Then the agreement which is enforceable by law means a contract, correct? But now for being a contract, all the essentials should be presented, and one of the essential was free consent, correct? One of the essential was free consent. If you are getting any of the if you are getting acceptance by way of because of coercion, undue influence, fraud, mistake, misrepresentation, then our contract becomes a voidable contract. Please mention that all the contracts which are not you can say accepted please mention that if all the contracts which are not having free consents are voidable contracts and not a void contracts. Okay, so understand here, A threatened B to shot him, so obviously there is no free consent, correct? So there is a coercion, and that's why it is not a valid contract, because there is a coercion. The third is, A agrees to sell house to B against 100 kgs of cocaine, that is drugs. So first of all, selling drugs or giving drugs as a consideration, obviously it's an unlawful or illegal activity. So consideration which you are getting is illegal, unlawful, hence one of the essential is again missing, so it is not a contract. Next, A asks B if he wants to buy his bike for 50,000 and B agrees to buy that bike. So here A is asking and the B is saying that yes. So A have the offer, B is giving the acceptance. There is a consideration. It is adequate or not doesn't matter, but there is a consideration, and hence it is enforceable by law and it becomes a valid contract. So agreement is a valid contract. Now Mr. X agrees to write a book with the publisher, but after a few days, what happened is, after a few days X dies in an accident. So here understand, writing a book, obviously it involves some personal skills, correct? So now here if there are some personal skills involved, it becomes impossible to perform that particular agreement or that offer, acceptance, whatever the contract you have considered, it will become difficult. So because of supervening impossibility, correct, or subsequent impossibility, hence this contract is not valid contract because of impossibility of performance. So here first consensus ad idem was missing, second coercion was there, third illegal contract, illegal consideration or unlawful consideration, fourth it was a valid contract, and fifth it becomes impossibility of performance. So here the first question of regarding or on the specifically based on whether the contract is valid or not. The second question is, Mr. Harish owns payment of payment of 3 bills. Okay, Mr. Harish owes payment of 3 bills to Mr. Ashish. So one is Harish, the second is Ashish. As on 31st of March, the payment due are, first payment is of 12,120, the second payment due was of rupees 5650, and the third is 9680. This question you will be getting in your module exercise also. So this question is quite important, maybe because this is given in your module also, this is given in current year's RTP also, and this question was there in the past examination paper also and in MTPs also. So please mention that this question was asked many times and this question is presented at many places. So maybe possible this question is quite important. So please mark it as important, because this question is based on section number 59, 60 and 61, which was talking about the appropriation of payment. So here they are asking that Mr. Harish made the payment on the 1st of April 2022 without any notice. So here some specific hint is given, that is this payment or these checks are given without any notice. These two checks are there, and now we supposed to advise on the basis of these on the basis of provisions of Indian Contract Act 1872. So the first is a check of 9680 and the second check is of rupees 15,000. So first is 12,5650. So your liability is 12,965650 and the third is 9680. These are the three payments which are due, correct? And now they are making the payment of by check. One check is of 9680, the second is 15,000, and the third mention, the note you supposed to mention is of without any notice. So please focus that whenever you see the word without any notice, that doesn't mean immediately you should say appropriate according to whatever the wish of the dater or Mr. Mr. Ashish. So you can't write like this. Why? Because understand, there are some implied acts as well which may give some specific notice. For example, in the first place, they are saying that a check of 9680 is given. So now it is very clearly you can see that the amount due of 9680 and the check is given of rupees 9680. So you can obviously settle these amounts. So understand, if this is not, even though the notice is not given or expressly he has not said anything. So understand, but there are some implied actions which will lead to a conclusion that yes, there is a notice that this particular check you should set off against this 9680. So this 9680 against this 9680 you should settle down. And the second check is of 15,000. So 15,000 against, obviously, so there is no due amount of rupees 15,000, correct? So you can apply proportionately. So first you will apply according to FIFO method, or you can say that according to the debts due, or according to the discretion of the person who is going to receive this money. So either you will, so 15,000 you will first settle down against 12,000, and the remaining amount you will settle against the 5650. So please mention that if there is no, even though there is no notice, but still there is a notice impliedly given by Mr. Harish. So this is the second question. Now we will go to the third question. Third question is, Mr. Shyam Mudra was a businessman having one son and one married daughter. So one son is there, one married daughter is there, and Mr. Shyam Mudra is there. Okay, so 3 person. He decided to gift. He means who? Mr. Shyam. Mr. Shyam Mudra decided to gift his house to his daughter. Okay, so his daughter, he is giving. See, this is Mr. Shyam Mudra. Okay, so this is Shyam. He is gifting house. This is house. Assume that this is house, and this house he is gifting to his daughter. To his daughter. Okay, gifting. Now, for the purpose, he called his lawyer to his house and made a written document for such gift. Okay, here already have some everything mentioned. A written document is there. The lawyer advised him to get the transfer document properly registered. He is saying that this document, this gift deed should be properly registered. When they both were going for a registration of document, he met with an accident and both died. So later the daughter found that this document and claimed that this house belongs to me because there was a properly written document which was given by Mr. Sham as a gift deed. In the according to the gift deed, this house is gifted by Mr. Sham to his daughter. Now what will happen in this situation? Understand, whenever you are gifting somebody, that means you are giving something. So now there is nothing in return you are getting, correct? So if there is no consideration, no contract, we can say that no consideration, no contract usually. But understand, there are certain exceptions as well for this specific no consideration, no contract, which is given under section 25 of Indian Contract Act. So one of the exception is where you can gift this out of love and affection. But understand, whenever you are giving this out of love and affection, you should understand along with that 4 conditions you are supposed to complete whenever you are saying that you are gifting anything out of love and affection. Which are the 4? First of all, there should be a written document. The second thing is the parties should be in a near relation to each other. The third is even though there should be natural love and affection. And the fourth is whatever the gift you are giving, that should be a returned and properly registered document, correct? The properly registration has to be there, then only you can say that it is given under exceptional clauses, that is under section 25. Even though there is no consideration, still it will be considered as a valid contract. But after fulfilling 4 conditions, one is near relation with each other, the second is there should be some the natural love and affection, the third is the document should be written document, and it should be properly registered also. But in this situation, the document, because even the document is in written form, but it is not a registered document, and that's why it is not considered as a valid contract, and that's why you can say that hence the transfer is not enforceable. This was quite tricky one because of only one word, that was not registered. So only on the basis of one word they have formed the entire question. So please understand, even though it is in a written form, because it is not registered, this transfer is not a valid transfer. So we are done with the question number 3. Now we'll go ahead with the question number 4. Question number 4 is what? Question number 4 is Mr. Mukund wants to sell his car. Mr. Mukund wants to sell his car. Okay. For the purpose of this, he appoints Mr. Parth as a minor. So so one is Mr. Mukund. He is Mr. Mukund, and he is appointing one person, Mr. Parth. But this person is a minor person, and this person is the agent of Mr. Mukund. Now what happens? Mr. Mukund instructs Mr. Parth that car should not be sold at a price. It should not be sold at a price less than rupees 2 lakh. And Mr. Parth, he is a minor, and he completely ignores the instruction given by Mr. Mukund, and he sells the cars to Mr. Naman for rupees 1.5 lakh. So understand what is happening. So Mr. Mukund is there. There is one car. Okay, understand, assume that this is a car. Only assume this is a car. Okay, this is a car. Now Mr. Parth is selling this car. There is a clear instruction that it should not be less than 2 lakh. He should not sell at all to anyone for less than 2 lakh. Now he is selling this car to Mr. Naman for 1 point. This is Mr. Naman. This is Mr. Naman. He is selling this car to one of worth rupees, which should not be sold by him for rupees. So here you can see that there is Mr. Naman also. Now understand that he is selling, that is Parth being a minor, he is selling that car to Mr. Naman for rupees 1.5 lakh. So here understand, clear instruction is given. It should not be sold for less than 2 lakh, but he is selling that car to Naman for rupees 1.5 lakh. What will happen? Understand, can Mr. Mukund can recover the loss of rupees 50,000 from Mr. Parth. That is, first of all, he is a minor, and now he is asking that Mr. Mukund, being an adult person, can he claim that worth 50,000 loss, 50,000 worth of loss worth rupees 50,000 from Mr. Parth, and can he recover his car from Mr. Naman also? So first of all, minor is there. So all the provisions of minor you should recollect, and then you know that minor is liable only in case of liabilities, that too necessary liabilities, and necessaries, he is liable only for necessaries, correct? He is not liable for anything else than that. This particular situation is not covered under that necessary situation. So hence, obviously Mr. Mukund cannot claim that car. He cannot recover loss worth rupees 50,000 from Mr. Parth. The second is, Mr. Mukund can cover his car from Mr. Naman. Obviously not, because understand, don't write directly Mr. Naman has bought the car in a good faith, and he got the car by the third party and based on the provisions of Sale of Goods Act. The question was all about the Indian Contract Act, so you should specify all the provisions of Indian Contract Act and not of the Sale of Goods Act. So understand, here you should mention that yes, even though it's a principal agent relationship, because Mr. Naman has got the car and he purchased it from the his agent, hence he cannot recover that car as well. So he cannot recover the car also, and he cannot recover loss of 50,000 also, because he appointed minor as his agent. So all the acts done by the minor, it will be considered as all the acts are done by the principal itself, and he cannot claim anything. The next question is question number 5. It's quite important question from your examination perspective also. So understand, one here, Mr. Mukesh is running a grocery store in Delhi, and he sell his grocery business, including the goodwill of worth rupees 1 lakh to Mr. Rohit for the sum of rupees 5 lakh. Understand, here Mukesh is there, okay, here Mukesh is there, he is selling his business and along with the goodwill also to Mr. Rohit, for rupees 50 lakh, okay, for rupees 50 lakh. Now this 50 lakh, after the sale of the goodwill, Rohit made an agreement with Mr. Mukesh. He made an agreement with Mr. Mukesh, and according to agreement, Mr. Mukesh cannot open another grocery shop, another grocery store or similar kind of business whole of India for the next 10 years. So they have the agreement that he cannot open any grocery store for the next 10 years. However, Mr. Mukesh opened another grocery store, and in the same city within the 2 months itself. Now, what rights are available with Mr. Rohit and Mr. Mukesh, according to Indian Contract Act, you're supposed to specify. Understand, in this situation, what is happening is, Mr. Mukesh, this question specifically based on the restrictions for doing some similar kind of a business. So all the contracts where you are already specifying the that restrictions that you cannot carry out the same business after this for so many days, or within this much of local limit or something like that. All these provisions will be valid provisions provided they are reasonable. If they are so much extensive, or they are not reasonable, they are exploitative kind of in nature, then they are not valid restrictions. So hence here, understand, first of all, his goodwill is worth 1 lakh. He sold it to Mr. Rohit for rupees 5 lakh. Then secondly, they are making an agreement, and this agreement for 10 years, and that too for whole of India. See, understand, either you restrict certain local limits, say assume for maybe for 20 kilometers or something for the entire his life, or maybe for 10 years, or else you specify that for next 10 years, maybe for 10 months you cannot open a store or something like that. So either time restriction or place restriction, but that too also, even though you want to combine these two, that has to be very reasonable. But in this situation, it is not given a reasonable restrictions, and hence understand what they are saying, that according to section 27 of Indian Contract Act, this agreement that restrain a person from carrying out a lawful trade, profession or a business is a void agreement. First of all, it's void only. First of all, restrictions are void, but there are certain exceptions that if there is an exception in case of whenever you are selling a goodwill. So sale of goodwill is one of the exception, and this exception is saying that where the restraint is refrain from carrying out the similar business, but this should be within the specific local limits or for the specific period of time, and this restraint should not carry the similar business after the sale of the goodwill to the buyer for a price. It should be reasonable. It should be always be reasonable, and if it's reasonable, then only you can say that okay, it's valid. But if in this situation the restrictions are not reasonable, and hence this contract is void contract, or this agreement is a void agreement because they are not reasonable. So according to section 27, these restrictions are very not relevant, or not they are too restrictive and they are not reasonable, and that's why they are saying that it is not allowed. The next is, so it is quite important. You may get one of the question on section 27, or you may get a question based on section 27 of Indian Contract Act along with the section 11 and 36 of Indian Partnership Act, clubbing these three provisions. But let's see what happens in your exam. But this section 27 of Indian Contract Act is quite important, so please go through that particular section along with their exceptions. The next question is question number 6, that is P left his carriage on these premises. Okay, landlord of D seized the carriage against the rent due from D. Okay, so there is one P person, and he has left his carriage, and now against the rent he is settling his whatever the amount, whatever the assets, or you can say he is having something of which belongs to Mr. D and Mr. P, and P left that thing over there. Let's assume this was the thing which he forgot. Now Mr. P, this is the ownership of this particular thing is of Mr. P. Now he is saying, Mr. D is saying that he is settling down his rent due against this asset. Now what can happen is, can Mr. P recover the amount from Mr. D? The question is, can Mr. P do so, and can Mr. P recover the amount from Mr. D? Understand what happens in this situation. This question is based on basically section number 69, which talks about the interested person where the payment of money is due. So legally, obviously payment is due, rent was due, but what happens is section 69 of the Indian Contract Act states that a person who is interested for the payment of money which another person is bound to pay legally, and who therefore pays it and is entitled to get reimbursed from the another. In this given situation, D was lawfully bound to pay the rent. Obviously, P was interested in making the payment to D. D, that is landlords, as his carriage was seized by him, and hence being interested party, P made the payment and can also recover the same amount from D as well. So he can recover according to section number 69. The next question is quite important, is all about the Sale of Goods Act and Delivery concept question. Question number 7. So first 7 question, quite important. Understand what is happening. Mr. Ayuk purchased 100 kg of wheat from Mr. Bhaskar for rupees 30. So one here we have Ayush and one here we have Bhaskar. Okay, what is happening that 100 kgs of wheat for rupees 30. He is a buyer, he is a seller. Okay, here they are buying 100 kgs of wheat. Now, what is happening? Mr. Bhaskar says that wheat is in the warehouse of Kishore, and that is the Kishore who is a warehouse keeper. Kishore confirmed that Ayuk that he can take the delivery of wheat from him until the day he is holding the wheat on Ayuk's behalf. Okay, Ayuk is a buyer. On his behalf, Kishore is holding that wheat which is in the warehouse of Kishore, and that was earlier. That was the ownership of, on that wheat, earlier the ownership was of Mr. Bhaskar, but now it's of Mr. Ayuk. Before Mr. Ayuk picks the goods from a warehouse, the whole wheat in a warehouse as flowed in the flood, and now Mr. Ayukt wants his price on the contention that no delivery has been made by the seller. Now, and according to Sale of Goods Act, you supposed to answer. Understand now already delivery concept. There are three types of deliveries. One is symbolic, the second is constructive. If you guys remember, first is symbolic, the second was constructive, and the third was the symbolic, constructive and actual delivery, correct? In actual delivery, you supposed to give the goods. In constructive and symbolic, if you guys remember that key we used to give, and the constructive was specifically used to talk about the giving the delivery by the acknowledgement, correct? The word should be there, yes, constructive delivery or the delivery by acknowledgement. If you are giving the delivery by acknowledgement, already you have transferred the ownership of that goods, and risk follows ownership. That means very clearly they have said that whosoever is the owner of that goods should bear all the loss. So if there is a flood, and if the already or if you are not getting that wheat because of that flood, that means you are responsible, you as a buyer is responsible, and you cannot take that price back from him, because with the contention that seller has not done that delivery completely, but he has already delivered you the goods and under the head of the constructive delivery. So obviously, even though he is Mr. Kishori was in the possession, but he was in the possession on behalf of Mr. Ayukt and not on behalf of Bhaskar, according to constructive delivery. Hence, Mr. Ayukt cannot claim back the price. So it was quite important. So you can star mark this question. The next is question number 8. Question number 8 was Priyansh order an iron window to an iron merchant for his new house. The iron merchant sends his technicians to take the size of the window. So one Priyansh is there. He is sending. He has ordered that iron window to his new house, and he is sending somebody. Some person is sending somebody to take that size of the window and all. The technician come at the site and takes the size area of the window. Afterwards, iron merchant discuss the technicians, intimate the pricing, everything, gave the advance also. But now what happens is that this window, after 3 days, the technician was supposed to try to fit that window, but he failed to, and it was noticed that the size of the window was not proper, and hence Mr. Priyansh requests that iron merchant either to remove the defect or return his advance. Either you remove this defect or you can give back my advance. The iron merchant replies that the window was not specifically made for his site and the defect cannot be removed, nor it can be nor can it be used for any other, like that particular window, obviously for that specific measurement window they have prepared for. But now because this happens, what is happening is he cannot ask for the refund according to that iron merchant, and Priyansh should give him the balance of rupees 4,000. According to iron merchant, he should give 4,000 rupees. According to Priyansh, he should either give back the advance or he should remove the defect. Now you have to answer according to the Sale of Goods Act 1930 whether Priyansh can take his advance back or not. Understand, whenever you get the question, whenever you are writing the conclusion in case study based question, please write according to what we used to write in your childhood. Exactly opposite one liner to the question which they are asking, that whether Priyansh can recover his advance back or not. Either yes or no. Yes, Priyansh can recover. No, Priyansh cannot recover. Don't write entire provision in the conclusion itself or a kind of a paragraph in the conclusion. So please, first thing, you should focus on that writing practice. You should do that writing practice also. I have already uploaded one video on that. Then secondly, how to write your entire paper, and when you are getting case study based question, provision, then facts, explanation, and then conclusion according to the number of marks you are getting. Now we are going to write this question according to the section 16 of Sale of Goods Act 1930. Now here they are saying that there is an implied condition that goods should be under the merchantable position. Understand, obviously that we have already studied the implied conditions and implied implied warranties, correct? Implied conditions and implied warranties. This was one of the implied condition, that whatever the goods you are giving me as a seller or the seller is selling to the buyer, they should be according in a merchantable position at the time of the transfer of that particular property. Now sometimes the purpose for which the goods are required may be ascertained from the fact or the conduct of the parties of the sale, or by the nature of description. Now understand, whenever you are saying that you are selling the goods, now this sale of the goods can be either according to the implied acts of the conduct of the parties, or it should be according to the nature or the description whatever they have discussed among each other. Now in this case, the buyer need not tell the seller the purpose for which he is buying that iron window, correct? He hasn't mentioned, the buyer did not mention, and now he is not giving him the real facts why he is buying that iron window and everything. Now on this basis there is it is very clear that the window size was not proper, the window was not in a merchantable condition, and hence the implied condition of as to merchantability was not fulfilled, and Priyansh has the right to avoid the contract and can recover his advance money back. Obviously, because if we are saying that if we want this iron window for this particular area, so you should take the proper measurement, you should prepare according to that, and then you should fit. But if it is not fitting, and then you cannot say that we can't use anywhere and then we cannot give you advance back. So it should not happen, and that's why accordingly he can recover his advance money back. Next question is question number 10. This was all about question number 8. Now we are going ahead with the question number 9. The question number 9 is, Ayushman is the owner of residential property situated in Indraprasth Marg, New Delhi. Okay. He wants to sell his property, and for this purpose he appoints Mr. Ravi as a merchantable agent in the condition that Ravi will not sell the house at a price less than 5 crore. Now Ravi selling this house to Mudit for rupees 4 crore in a good faith, and Ravi misappropriated the money received by Mr. Mudit. So now understand, there is one person who is Ayushman. He is having that property. He is saying that he is selling this property. He want to sell this property, and he is saying to Mr. Ravi that you should not sell this property below 5 crore. But Ravi sold this to Mr. Mudit. So 3 persons. One is Ayushman, who is the owner of the property, correct? Owner. Now he is the owner of this particular property. Let's assume this is the building. He is the owner. This building he is selling. He is saying to Mr. Ravi, who is the agent, that this building should not be selling less than 5 crore. Okay, he should not sell. But now he is selling this to Mr. Mudit for rupees 4 crore. Now what will happen? Mr. Mudit, he is getting for 4 crore. Now, and that too, Mr. Ravi misappropriated this money also. Whatever 4 crore he got, he misappropriated. Ayushman files a suit against the Mudit to recover the property also, and according to Sale of Goods Act. Now you supposed to mention according to Sale of Goods Act. First of all, whenever you are selling the property in the capacity as an agent, you are coming under the section 27 of Sale of Goods Act 1930. Like, even though you are a mercantile agent, you have all the rights what the principal is having. But namely, you should focus on 3 things. First, if he is in the possession of the goods and with the consent of the owner, that means Mr. Agent, whosoever is the agent, in our situation Mr. Ravi, should be in a possession of the goods or the document, whatever the goods asset he wants to sell, he must be in that possession, but that too with the consent of the seller or the owner. The second is, if the sale is made by him means Mr. Ravi, when he is acting in the ordinary course of business, and they are not saying or, they are saying and he has if the buyer has acted in a good faith, because buyer was not aware whether he is having authority or not having authority or anything, he is buying in a good faith, that is Mudit was buying in a good faith. If these 3 conditions are satisfied, then what happens is, hence Mr. Ayushman cannot recover the property from Mudit. Rather, Ayushman can recover the loss from Mr. Ravi because he has not followed proper instruction which was given by Mr. Ayushman. So Ayushman has given proper instruction. There was a principal agent relationship, but because the agent did not work in a right way, or whatever the instruction was given, he did not follow them, Ayushman, the owner, should receive the loss, should recover all the loss from that agent and not from Mr. Mudit, who is the real owner now, the next buyer of that property, because he has acted in a good faith. So good faith was the very important word here. Now we are going ahead with the question number 10. Question number 10 is, A agrees to sell certain goods to Mr. B on certain day on a 10 days credit period. Okay, that period of 10 days expired and the goods are still in the possession of A. A is selling to B. He is in the possession. That means possession is given is with the B of the goods for a 10 days credit period. Okay, 10 days are already over and he is not giving back those goods. Now B has already not paid the price of the goods and B becomes insolvent also. Now the buyer is becoming insolvent also and he has not paid the price. That means he is the unpaid seller. Mr. A becomes the unpaid seller, first thing. Secondly, Mr. B becoming insolvent. That means unpaid seller rights. One of the right was stoppage in transit, stoppage in the right of lien, right of stoppage in transit. You should remember all those rights here. Now whatever is applicable will be applicable, but you should recall all the rights which are with the unpaid seller. Now A refuses to deliver the goods and to exercise his right of lien on the goods. Can he do so? What happens is, understand here yes. Now, the first of all, what is right of lien? Right of lien is to retain the possession of the goods. Retain the possession of the goods belonging to the another until claim of the person is in the possession of is satisfied. The unpaid seller have the right of lien, but when under these three situations. When first, where the goods have been sold without any stipulation as to credit, that means goods are not sold on the credit. Second, the goods are sold on a credit and the credit term has expired. The credit term has expired. And the third is when the buyer becomes the insolvent, even though the credit period has yet not expired. Understand, even though the 10, see here we have two conditions. One was buyer is becoming insolvent and the second is credit period is also over. Now he can be covered under these two clauses. But understand, if even though the credit period has not been completed, that means within 5 days itself B becomes insolvent, then you can cover him under third point. But if the credit period is already what you can say entirely ended, and along with that he is becoming insolvent also, then the point 2 and 3 you can apply. Now in the given situation, whatever is happening they have mentioned here, and hence what happens, the conclusion is A is entitled to exercise the right of lien because the buyer is insolvent and the credit period has also ended, and that's why you can apply point number 2 and 3 and you can exercise right of lien as a seller. That means A can use his right of lien on the goods. This all provision was given under section 47 of Sale of Goods Act 1930. So understand these 3 points you supposed to mention and then you can get the marks. The next question is state the difference between sell and agreement to sell. Very clearly given, a straightforward question already given in your what you can say, given in your modules also, in your notes also. Now we are going ahead with the next question, that is question number 12. Mr. Ram and Mr. Rahim. What happens is with Mr. Ram and Rahim, Mr. Ram and Mr. Rahim are working as a teachers of Ishwar Chand Vidyasagar High School, and they are good friends. What happens is they jointly purchased a flat and was given on a rent to Mr. John. They are buying a flat and they are giving it on a rent to Mr. John. It was decided between the landlords and the tenants that whatever the rent he is giving, that was 10,000 per month and inclusive of electricity bills was paid by landlords. That's okay. The landlord by mistake did not pay the electricity bill for the month of the March 2021. Okay. Now due to this, the electricity department cut down the connection. Okay, so the electricity was actually about to pay paid by Mr. Ram and Mr. Rahim, but they did not pay. Hence, the electricity cut down. And now what happens is Mr. John is supposed to pay the electricity bill of rupees 2,800 plus 200 as a penalty. Now he want to claim this 3,000 from Mr. Ram, but Mr. Ram replied that he is liable only for 1,500. Why? Because Mr. John said that Mr. Ram and Mr. Rahim are the partners, and therefore he can claim the full amount from any of the partner. Explained under the provision what Mr. Ram, Mr. John, according to them, you should write everything according to Indian Partnership Act. Now understand, here being a partner, you should be having 5 essential elements in that particular partnership. The first is there should be a business. Second, 2 or more person. Third, there should be an agreement. Fourth, there should be a profit sharing. And fifth, there should be a mutual agency. In the given scenario, there is just a building for which they are sharing a rent, but the first and what you can say prima facie or conclusive evidence of being a partner, whether you should mention whether you should specify anything as a partnership or not, mutual agency is a prima facie conclusive evidence. Not only sharing of profit is essential, but prima facie is mutual agency. In this situation, Mr. Ram and Mr. Rahim are not the partners, they are just the co-owners of each other. And according to that true test of partnership, they are not partners, they are just co-owners. And that's why what happens is Mr. Ram and Mr. Rahim should, let me just connect the charger. So in this situation, understand, Mr. John can claim, therefore Mr. Ram is liable to share 1,500 and Mr. Rahim 1,500. This should not happen that they are partners and they are jointly and severally liable. So they have the unlimited liability. So Mr. John can ask for compensation from any of the partner, the entire compensation. This cannot happen. Mr. John should ask for share of rupees 1,500 from Ram and 1,500 from Rahim, because they are not the partners, they are just co-owners of the business. Here they have mentioned the section 4 definition of partnership. Otherwise, this you can write and then you can write the conclusion. The next question is question number 13, which talks about, there is Mr. Shyam, Mohan and Keshav. They were partners in one of the company. They mutually decided that Mr. Shyam will take the responsibility of selling the goods. Mr. Mohan will do the purchase of goods. So selling, Shyam, Mohan will purchase and Keshav will look after the accounts. So these were the duties which they supposed to fulfill. No one will interfere in each other's department. Okay. Now once the Shyam and Keshav were out of town, Mohan got the information that the price of the goods is going to sharply due to the government policy, and they would result in a heavy loss to the firm if the goods are not sold immediately. What happens is, if the prices are going down very quickly, and if even though he is not in the authority, he want to sell all those goods immediately if he want to save his firm from the losses. But he is not having any authority. What will happen? He tried to contact Mr. Shyam also, who actually having the authority. Who was having the authority? Mr. Shyam, for selling of the goods. Now what is happening? He is contacting Mr. Shyam, but he is not able to connect with him. When Mohan couldn't connect the Shyam, he sold the goods at a reduced price to save from the heavy loss, to save the firm from the heavy losses. And now what happens? According to Indian Partnership Act, you should specify all the provisions. Obviously, first and foremost important provision is the person should have the authority, correct? But this kind of situation, you can say that there is an emergency kind of situation which is given under section 2021 of Indian Partnership Act. So in case of you are acting in an emergency situation, you should act as if this you should have done for your own firm as well. So here they should everything was binding on all the partners. Because why? Because this entire provision is based on the emergency situation, that is section 20 and 21. Section 20, section 21, this authority, even though he is not having, he tried to connect with the person who is having the authority, but he failed to, and just to save his firm, he is acting in a good faith to save from all the losses, and he acted as if in the ordinary prudence anyone has acted, and that's why he has entire, for such acts the firm is binder to, the cell will be binder. So you cannot say that the cell, because he is not having any authority, cell will not be binding on the firm. It will be. Why? Because according to section 20 and 21, this is the emergency situation. Next question is question number 14. Mr. X and Y are the partners in a firm. The firm was dissolved on the 12th of June 2022, but no public notice was given. Firm is already dissolved on 12th of June 2022. Now, Mr. X purchased some goods in the name of firm, even though the firm is dissolved, but because public notice has not given, he purchased the goods from Mr. Z. Now, Z was ignorant about the dissolution of the firm. Now, X becomes the insolvent. Z is filing the case against Y for the recovery of amount. Now, understand, whenever the firm is dissolved, you're supposed to give the public notice, and if you fail to give the public notice, still your partnership is not ended yet, and all the partners will be severally and jointly and severally liable. So in this situation, X and Y were the partners, even though X is in Z, the firm is dissolved, but because no public notice has been given, Mr. Z can ask money from Mr. Y, and Y will become liable according to the Indian Partnership Act. Everything is given in this situation. See here, suit can be filed and Y for the recovery of this amount, and yes, Y will be liable to Z is the conclusion. As simple as that. Let's go ahead with the question number 15. Question number 15 is, state the modes by which the partner may transfer his interest in the firm in favor of another person of the partnership. So here they are talking about section number 29 of Indian Partnership, that talks about the transferee and transferor relation. Whenever you are transferring your share in the partnership firm to any transferee, that transferee will not be having any right to enter in participate in the conduct of the business, or to check or inspect the books of accounts unless and until except in one situation, that is in case of dissolution of the firm or the retirement of the firm. Except this, he cannot ask for the books and conduct in the business. He cannot do anything. Whatever the share he is getting, he should be happy with that. And now, hence, whatever the except in two situations, that is dissolution and retirement. So by the virtue of this, he is not even understand, according to section 31, he can't be saying that the transferee cannot say that he is the partner of the partnership firm. He is just a transferee. He is just entitled to receive the share. He is no more the partner, and he is not having any of the right what the partner is having the right in a partnership firm, because being admitted as a partner according to section 61, according to section 31, consent of all the partners is necessary. But here in this situation, he is not a partner, so he is only he is only the transferee. So this much you should write in your exam. Next is small LLP. I have already told you in your amendment lecture also, either you will get the question on small LLP or on small company. Small LLP means any company, any LLP which is having contribution not less than 25 lakh and turnover not less than 40 lakh. So that will be the small LLP. Next is question number 17. Question 17. Last 4 questions. For 17 question number is, in the Floor Funds Private Limited, there are 5 members. 5 members are there. It's a private limited, so minimum 2 members should be there. Okay. Now all of them go in a one boat and on a pleasure trip into an open sea, and the boat capsized, and all of them died being drowned. And now whether the firm will be going or not, whether they further it should be saying that company, being an artificial person, cannot own the property and cannot sue or cannot be sued. Understand, 5 members are there, but because it's not a partnership, it's a company, there is a separate legal entity concept. Partners, companies, members are different and company is different. Even though all the members are dead, doesn't matter. Company is having a perpetual succession. It is having a separate separate legal entity, company will continue even though all the members are no more. So first thing here, it's all about the perpetual succession which is there still, and hence they can be sued, and they can sue against all the properties. So yes, it's a perpetual succession, and being a company, it will go on and on even after the death of the partner, death of the members. The next is question number 18. ABC Limited was into the sell and purchase of iron rods. This was the main object given. See here, they are mentioning about the memorandum of association. Understand, you will get one question either on ultra vires, or on indoor management, or on memorandum and article. So out of these four concepts, you will get one question for sure in your exam. One of the question they have mentioned all about is object clause of memorandum of association. The company entered into a contract with Mr. John and for some work related, finance related work, and now they are saying that where this contract was not ultra vires contract, so you supposed to mention accordingly, you supposed to answer accordingly. So their main object was only related to sell and purchase and not related to finance. So whatever they are doing is beyond the capacity or beyond the powers of beyond the powers, because ultra vires itself is the beyond their powers. So this everything was beyond powers. It's a public document, obviously, no doubt about it, it's a public document. But even though after that, even after that, this act cannot be ratified. Even after that, this act cannot be ratified by the members, because it is not within the what you can say, within the power of memorandum itself. So hence this you can say, even though it's for public inspection, public document, this everything you're supposed to write all about the ultra vires. I would say just write, if this question comes for 4 marks, you should write 8 points. If this question comes for 6 marks, write 12 points. So which words are important? The first is beyond their powers, that is ultra vires. The second most important word you should write, it's a public document, available for public inspection. It cannot be ratified. Then next is the unanimous consent, even though after having unanimous consent. And the basic and the company law objects should be stated in memorandum. All those 4-5 points are important. Otherwise, this will become wholly void. This line is very important, that all the acts are done which are beyond the powers, then they will become automatically void and inoperative in the eyes of law. They are void, null and void, you can say, and then you can end your answer. The next question, second last question, is ordered with the question number 19. There are the board of directors given, they are given the powers to take a loan, but only up to rupees 5 lakh, and for this they supposed to pass a special resolution in a general meeting. But what happens is, board now, because of the needs of the funds, they are taking the loan from a reputed bank worth rupees 10 lakh, and now by passing a resolution, now what happens is, because this 10 lakh is beyond their limits which were specified in a special resolution, now what happens, whether the bank can recover that amount or not. Understand, this particular provision based on the indoor management, where the outsider will get the protection, where whatever the affairs of the company is happening, the outsiders are not responsible for them. Outsiders should not look into the affairs of the company, or they should just see whether the resolution is passed or not. They should not see whether the resolution is properly passed or not. So understand, whatever the properly, what is the limit, and they are not responsible to check that. And hence, if the resolution is passed, bank can give the loan, and the bank will get the protection, and bank can recover the entire amount of the loan under the indoor management. All right, because they will, being an outsider, they will get the protection. And last question, explain the classification based on the controls. Here you should write holding company, subsidiary company, and the associate company. Holding company means any company which is the subsidiary, which is the company of which the other company is having more than half of the voting power of that company, or controls the board of directors. And associate means where you will be having a significant control over the another company, and that significant control means you will be having more than 20% of that company. So this is all about the RTP. I hope you are done with the RTP along with me. we'll meet in the next session along with the I guess MTP. I'll be recording next session will be on MTP 1 and MTP 2 related to law subject, and along with that we'll meet soon. Take care. Bye bye. Keep studying, keep revising, and all the best.